Criminal Procedure, Rule 117, Motion to Quash. Section 1, Time to move to quash. At any time before entering his plea, the accused may move to quash the complaint or information. Section 2, Form and Contents. The motion to quash shall be in writing, signed by the accused or his counsel, and shall distinctly specify its factual and legal grounds. The court shall consider no ground other than those stated in the motion, except lack of jurisdiction over the offense charge. Section 3. Grounds. The accused may move to quash the complaint or information on any of the following grounds. A. That the facts charged do not constitute an offense. B. That the court trying the case has no jurisdiction over the offense charge. C. That the court trying the case has no jurisdiction over the person of the accused. D. That the officer who filed the information had no authority to do so. E. That it does not conform substantially to the prescribed form. F. That more than one offense is charged except when a single punishment for various offenses is prescribed by law. G. That the criminal action or liability has been extinguished. H. That it contains averments which, if true, would constitute a legal excuse or justification. And I. That the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without his express consent. Section 4. Amendments of complaint or information. If the motion to quash is based on the alleged defect of the complaint or information, which can be cured by amendment, the court shall order that an amendment be made. If it based on the ground that the facts charged do not constitute an offense, the prosecution shall be given by the court an opportunity to correct the defect by amendment. The motion shall be granted if the prosecution fails to make the amendment, or the complaint or information still suffers from the same defect despite the amendment. Section 5. Effect of sustaining the motion to quash. If the motion to quash is sustained, the court may order that another complaint or information be filed except as provided in Section 6 of this rule. If the order is made, the accused, if in custody, shall not be discharged unless admitted to bail. If no order is made, or if having been made, no information is filed within the time specified in the order, or within such further time as the court may allow for good cause, the accused, if in custody, shall be discharged, unless he is also in custody of another charge. Section 6. Order sustaining the motion to quash, not a bar to another prosecution, except an order sustaining the motion to quash is not a bar to another prosecution for the same offense unless the motion was based on the grounds specified in Section 3, letter G and I of this rule. Section 7. Former conviction or acquittal, double jeopardy. When an accused has been convicted or acquitted, or the case against him dismissed or otherwise terminated without his express consent by a court of competent jurisdiction, upon a valid complaint or information or other formal charge sufficient in form and substance to sustain a conviction, and after the accused had pled to the charge, the conviction or acquittal of the accused or the dismissal of the case shall be a bar to another prosecution for the offense charge, or for any attempt to commit the same or frustration thereof, or for any offense which necessarily includes or is necessarily included in the offense charge in the former complaint or information. However, the conviction of the accused shall not be a bar to another prosecution for an offense which is necessarily includes the offense charge in the former complaint or information under any of the following instances. A. The graver offense developed due to supervening facts arising from the same act or omission constituting the former charge. B. The facts constituting the graver charge become known or were discovered only after a plea was entered in the former complaint or information. C. The plea of guilty to the lesser offense was made without the consent of the prosecutor and of the offended party, except as provided in Section 1, letter F of Rule 116. In any of the foregoing cases, where the accused satisfies or serves in whole or in part the judgment, he shall be credited with the same in the event of conviction for the graver offense. Section 8, Provisional Dismissal. A case shall not be provisionally dismissed except with the express consent of the accused and with notice to the offended party. The provisional dismissal of offense punishable by imprisonment not exceeding 6 years or a fine of any amount or both shall become permanent 1 year after issuance of the order without the case having been revived. Again, the provisional dismissal of offenses punishable by imprisonment not exceeding 6 years or a fine of any amount or both shall become permanent 1 year after issuance of the order without the case having been revived. With respect to offenses punishable by imprisonment of more than 6 years, their provisional dismissal shall become permanent 2 years after issuance of the order without the case having been revived. Section 9. Failure to move to quash or to allege any ground therefore. The failure of the accused to assert any ground of a motion to quash before he pleads to the complaint or information, either because he did not file a motion to quash or failed to allege the same in the said motion. He shall be deemed a waiver of any objection except those based on the grounds provided for in paragraph A, B, G, and I of Section 3 of this rule. Rule 118, Pre-Trial, Section 1. Pre-trial, mandatory in criminal cases. In all criminal cases cognizable by the Sandigang Bayan, Regional Trial Court, Metropolitan Trial Court, Municipal Trial Court in cities, Municipal Trial Court, and Municipal Circuit Trial Court, the court shall, after arraignment and within 30 days from the date the court acquires jurisdiction over the person of the accused, unless a shorter period is provided for in special laws or circulars of the Supreme Court, order pre-trial conference to consider the following. A. Plea bargaining. B. Stipulation of facts. C. Marking for identification of evidence of the parties. D. Waiver of objection to admissibility and of evidence. E. Modification of the order of trial if the accused admits the charge, but interposes a lawful defense. And F. Such matters as will promote a fair and expeditious trial of the criminal and civil aspects of the case. Section 2. Pre-trial agreement. All agreements or admissions made or entered during the pre-trial conference shall be reduced in writing and signed by the accused and counsel. Otherwise, they cannot be used against the accused. The agreements covering the matters referred to in Section 1 of this rule shall be approved by the court. Section 3. Non-appearance at pre-trial conference. If the counsel for the accused or the prosecutor does not appear at the at the pre-trial conference and does not offer an acceptable excuse for his lack of cooperation, the court may impose proper sanction or penalties. Section 4. Pre-trial order. After the pre-trial conference, the court shall issue an order reciting the actions taken, the facts stipulated, and evidence marked. Such order shall bind the parties, limit trial to matters not disposed of, and control the course of the action during the trial, unless modified by the court to prevent manifest injustice.